Ms. Smith, is there any reason not to go forward with sentencing at this time, with those matters being addressed?
None that I'm aware of, Your Honor.
All right, is there anything you would like to say then at this time on behalf of your client?
I would, Your Honor. Prior to coming to court today, I did have opportunity to review the pre-sentence report and also review it for any inaccuracies or inconsistency with the information my client has reported to me, and I found none.
Thank you.
Your Honor, the magnitude of this case, I'd like to outline for the court, although we are aware that it was serious and the indictment was large, just for purposes of context. Mr. Sinclair started out charged in 2 cases with 19 total counts, ranging from misdemeanors through first-degree felonies, and was facing approximately 44.5 years in prison. The victims in this case are widespread. They include his wife, Lisa, her, unbeknownst to my client at the time, lover, 2 of their children, 2 of the children that are shared by, have been raised by my client and his wife, a school resource officer, children who attended a school, the parents of those children, the public interest, when you consider the law enforcement response that was required based on the sequence of events and their location that day. The harm in this case was widespread, but the seriousness of the physical harm to each individual was minimal, and I specified physical there for a reason. The psychological harm is difficult to determine. We don't have any individual reports from the children in the school that I'm aware of as to what lasting effects this may have on them. There's also the psychological effects that this would have on Mr. Sinclair's own children and a child and the children he was raising as his own. The harm in this case, however it can be added up, was disproportionate to what the indictments suggest. The location of this incident being adjacent, essentially, and on the property of a school, an elementary school at that, and the occupation of Mr. Sinclair made this case and his conduct that day a big boom, but a relatively small blast when we consider other similarly charged offenses. On that day, many were afraid. However, luckily, thankfully, nobody's worst fears. Mr. Sinclair pled to 7 counts and now faces approximately 28.5 years in prison after Reagan-Tokes is applied. Mr. Sinclair's remorse is deep, and we will elaborate on that further. Mr. Sinclair has made it clear to me that he does not want the lesson that he has to learn and the lesson that other people can learn from his bad choices on this day that will likely be one of the worst of his and others' life. He does not want that to be wasted. He's indicated he wants his conduct, his decisions, his mistakes and their consequences to serve as a lesson to all, whether or not those people are law enforcement officers. And the lesson is that one day, one choice can change everything. Neglecting your mental health and your personal well-being leads to unhealthy and bad choices with devastating consequences to yourself and to those who you love the most. A few facts of this case that are relevant to the framework and the background upon which everything occurred are, as previously stated, Lisa Torba, one of the victims in this case, was Mr. Sinclair's wife. They had been married for 4 years. They got married on October 31st, 2020. This incident occurred on October 31st of 2024. The morning of October 31st, Mr. Sinclair and his wife woke up in their bed together, and they went about their normal daily tasks, getting the kids to where they need to go to and such. Ms. Torba arrived at her place of work, which is also the daycare that they utilize for their youngest daughter. She had one of their children with her, and Mr. Sinclair was taking one of the other boys to school and had their youngest in his car with him. He went up to his wife's place of work with their daughter, first to see if she was going to be going to school that day because she had a broken leg, and to take her an anniversary card. When he pulled into the parking lot, he found his wife outside of her car in a romantic entanglement with another man. This was devastating to Mr. Sinclair, and it does not excuse his conduct, but it does provide some explanation as to how he arrived at the mindset and in the precarious position he found himself that day. Also making the offense more serious is that Mr. Sinclair's relationship with his wife did facilitate the offense. He would have no feelings about her being in the arms of another man if they were not married. This was a domestic offense in nature with his wife and kids, making the offense less serious. Not all of the victims, because there are many, but several of the victims in this incident that day did both induce and facilitate the offense. Mr. Sinclair was strongly provoked. This was his 4-year wedding anniversary, and his wife had been in bed with him just hours before. There was no talk of separation or divorce prior to this incident. There were difficulties because Mr. Sinclair was growing withdrawn and despondent, but he learned that his wife was interested in seeing other people on the morning of this incident. Mr. Sinclair did not expect, although reasonably he perhaps should have, to cause physical harm to any person or property. He had a singular goal that morning, and it was to get that guy away from his wife. When we could look at the likelihood of recidivism, Mr. Sinclair is rather unique. His ORAS score is 6. He has a very low likelihood of recidivism. And making recidivism less likely with Mr. Sinclair, he was not on post-release control or probation at the time of the offense. He had no open warrants and had no history of criminal convictions at all. He has no juvenile adjudications. He had no incidents in the jail, and I state that with the awareness we should have here that our pre-sentence reports now indicate even the most de minimis jail violations. There is no history of of abuse of alcohol or other drugs, and Mr. Sinclair has real remorse. As he put it, he has tremendous regret, shame, sorrow. It was the worst day of his life, and he is devastated by his conduct. Additionally, Your Honor, the circumstances in this offense are unlikely to occur again. How many times does a married man learn in person that his wife has a new lover on their anniversary? Contemplating sentence is whether or not the individual served our country through its military. Mr. Sinclair has not. But I submit to the court, and any court that may review this case, that somebody's status as a police officer is very similar to the revere that we should have for what they do, and their role for our society is largely similar.
I'm going to interrupt you for 1 second. I don't necessarily disagree with you, but you can't have it both ways here with the next argument you're going to be making about that it can't consider that in terms of making it more serious. You want me to ignore his status as a police officer in terms of making it more serious, but take it into consideration for making it less serious.
My position,
or less recidivism. I don't know what factor you want me to consider it for, but you're asking me to take into consideration for some purposes and not other purposes.
Actually, Your Honor, what I'm asking the court to do is to consider that in light of the principle set forth in State v. Mole, that the 3 sentencing factors that would hold a law enforcement officer to a higher standard than the general public are unconstitutional and therefore should not be.
And I intend on following the law, the Supreme Court's decision in Mole. And I mean, the offense he committed has nothing to do with his role as a police officer. I don't think anyone's arguing that. And he didn't commit it. Like the factor that says that he's obliged to prevent the offense for which he was committed, that's for someone that commits an offense while they're engaging in this case, law enforcement work or police work, and that's not what we have here.
Then
I recognize that.
Now,
But if you're
When
going to
we
make
can-
the argument that I'm not allowed to consider the fact that he should have known better or known stuff because he's a police officer, but yet I should consider the fact that he was a police officer to give him more respect, I think that's inconsistent. I don't think you can have it both ways. But we can disagree to disagree, perhaps, but go ahead.
I think we actually agree more than we disagree,
All right.
Your Honor. But
That's a first,
I
but-
think it might be our phrasing that is a little where our disconnect comes in. When we do look at a military, someone who has served our country through the military, we're supposed to consider their service, any resulting physical or mental condition from their service, and if and how that condition is connected to the offense. And that gets to the heart of the parallel between our law enforcement officers and the members of our military. Well, law enforcement is not a combat role by definition. In many police districts, parallels could be made to war zones. Where somebody is acting to protect and serve us, whether it be our nation as a whole or a local community, and there is a resulting physical or mental condition from that service that is connected to the offense, I would ask the court to consider that. It's that specific as to Mr. Sinclair. So we'll get into the mental health component of this in a moment. The court is also asked to consider any other factors that are relevant to achieving the purposes and principles of sentencing via the least restrictive and burdensome means available and appropriate. Mr. Sinclair, prior to this offense, was a husband. He'd been married for 4 years. He was a Lake County homeowner and had purchased a home outright in the city of Madison in August of 2024, just 2 months prior to the instant offense. However, he had been a resident of Lake County for approximately 13 years before. He's a father. He considers himself a father of 4, at least prior to this offense. He has 2 biological children, one with Ms. Chorba and an older daughter. He's also the sole father figure, or had been up until this point, to Ms. Chorba's 6-year-old son, who does not have a father figure in his life, and is a stepfather to Ms. Chorba's oldest son. Mr. Sinclair's childhood was relatively normal. His parents were supportive. He had many extras, many privileges that a lot of the defendants in our court don't have. He was molested at the age of 4. He received family support, but no psychological services following that. Despite his early childhood trauma, Mr. Sinclair went on to play football from Pee Wee League through college. He plays the violin. He was in show choir. And he is fluent in both English and Russian. He graduated Brush High School in 2008 and then attended Hiram University on an academic scholarship. He graduated in 2012 with a Bachelor's of Science in both criminal justice and sociology. He then attended the Cleveland Police Academy, which he completed in 2015, and he then began working as a Cleveland police officer. Mr. Sinclair was promoted to detective within 4 years of starting his job. He became the public information officer for the entire city of Cleveland, which, for general awareness purposes, is a high pressure and high demand position. It requires that officer to be on call essentially at all times for any case of media interest or that would be directly of interest to the administration, and must stop what he is doing, must leave his family, whether that be Easter morning when a homicide is broadcast on Facebook Live, like occurred while he was the public information officer, or whether that be for some other event. But the role frequently led him to be pulled away from his family. He then was promoted to sergeant, and at the time of the incident, and prior to the incident offense, was working third shift in the 5th District in the city of Cleveland, which is one of the most violent districts in a city that averages more than 200 homicides per year. Mr. Sinclair has shared with the court on the day after this happened, as well as just about anyone who will listen, that he was struggling with mental health disturbances on the state. He believes that he suffers from depression and potentially post-traumatic stress disorder. He became withdrawn sometime before the event. His mother noticed it 4 to 5 months prior. His wife noticed it about 2 months prior. His other officers at work noticed that he was becoming withdrawn, and Mr. Sinclair himself was considering leaving policing due to the toll that it was taking on his family and his personal well-being. Mr. Sinclair did not neglect to seek help. He sought help. He received advice. He was told when he sought help for depression to get enough sleep, eat a well-balanced diet, and continue to exercise. And if his symptoms were to persist, to follow up. Well, his symptoms persisted, and he intended to follow up. One of the questions that were still to be resolved for the day on October 31st of last year was whether or not Charlie, the youngest, would be going to school that day because she had a broken leg. If their daughter had gone to school, Mr. Sinclair was going for a follow-up that day. Another place where Mr. Sinclair's depression is apparent in this incident is that after he was subdued by the school resource officer in this case, he asked him to shoot him. Mr. Sinclair has recently resigned from the Cleveland Police Department. He was allowed to resign in lieu of termination in connection to this offense and this only. While he was actively policing, Mr. Sinclair received disciplinary action on only 2 occasions. One occasion was for failing to complete a vehicle log. That occasion was tied closely to another occasion where he and another officer were reprimanded due to personal contact that shouldn't have happened in a city vehicle on duty. And the underpinning that situation is that Mr. Sinclair rejected the advances of a female officer. What is absent from Mr. Sinclair's personnel file is any accusation of unprofessional conduct when engaging with the public, any unjustified use of force. In fact, when I inquired as to how much force he had had to use in the past, despite policing one of the most dangerous districts in Cleveland at one of the most dangerous times of the day, has never fired his gun at a suspect. I'm not only Mr. Sinclair's attorney, I'm a Cleveland resident, and I came to this work through advocating for police reform. And it might be a little counterintuitive that Mr. Sinclair and I are sitting at the same table, but what I can offer to this court as a resident of the city that he policed and as a police reform activist, that losing Mr. Sinclair as a police officer is absolutely a loss to the city of Cleveland. He is the type of person that we begged for, that we need to become police officers. He looks like the young men who populate our city. And he is was an example of a way out for them, to show them that there were more choices out there for them than the ones that they saw directly in front of them. And he could empathize with them in a way that some other officers who didn't share similar histories may not be. The collateral consequences of this conviction for Mr. Sinclair cannot be overstated. Not only is he going to go to prison for this, he's lost his career, he's lost his marriage, whatever time he will be in prison, he will lose from his biological children, and the children that he considers his own, who he treated and raised as his own, are likely never going to be a part of his life again. He's lost the home that he purchased in Madison, and his entire life as he knows it. Mr. Sinclair will live with the consequences of his actions from October 31st, 2024, for the rest of his life, no matter what prison term the court imposes. We're also asking the court to consider, because an individual's conduct during the pendency of a matter is relevant to their consideration, we would like to consider the court to also consider the conditions of Mr. Sinclair's confinement while this case was pending. If I could have the screen.
You got it?
We'll call this Defense Exhibit A.
Now you got it.
And Defense Exhibit B shares the same purpose. This is Alexander Sinclair. I would ask you to look at the person sitting in the chair next to me, and I don't see it looks like the same person. Eighth Amendment protections don't apply to pretrial because nobody's being punished. The presumption of innocence applies. Additionally, Mr. Sinclair was not in isolation because he was being punished. He was in isolation for his protection because he's a law enforcement officer. In Ohio, there are statutory limits on how isolation can be used as punishment. And again, during this time, he was cloaked in the presumption of innocence. In Ohio, anything in isolation more than 120 hours requires administrative review. The maximum isolation sanction is 60 days. Continuous isolation over 30 days requires review and approval of a jail administrator. And an inmate must have a hearing within 48 hours of placed in isolation. These limits are in place because there's well-established academic research that the courts have adopted throughout this country on the deleterious effects that isolation has on the psyche and the physical health of an individual who's subjected to it. Mr. Sinclair has spent 209 days in custody, all but the last 2 weeks were in isolation. And this wasn't punishment. This wasn't because he needed to be thrown in the hole. This was for his safety and because of his status as a police officer. In the pre-sentence report, in the psychological evaluation, the assessor described Mr. Sinclair as thin, avoiding eye contact. He was restless. He was anxious with a flat affect, had a tangential thought pattern, and found that he met the diagnostic criteria for adjustment disorder. Now, the adjustment that is referenced in this diagnosis is that he has had, as anybody would, had difficulty adjusting to 23 hours a day, 7 days a week in isolation for 209 days. The pre-sentence report also notes that Mr. Sinclair, while he had a largely normal and positive upbringing with a supportive mother and family, that his trauma history is significant due to the policing, due to the first-hand witnessing of violent experiences over and over. Your Honor, when we look at the conditions of Mr. Sinclair's confinement, which he has a full understanding were to protect him, but when you look at the effects, we would submit that his punishment for his conduct on October 31st began the day of his arrest and has been, up until change of plea here, was disproportionately severe simply because of his occupation. Your Honor, I would submit that if this is the way that we protect those that have sworn to protect and serve us when police officers find themselves on the other side of the criminal justice system, then we as a society and a system are missing the mark. In light of everything that we have set forth for this court, as well as the information in the pre-sentence report and what was discussed in chambers, Your Honor, We are asking the court to impose a minimum sentence here of 6 years, 3 years on the felony of the first degree kidnapping, 3 years on the gun specification on that count, and 2 years on the firearm specification attached to the abduction, with the 3 and 2 year specifications being run concurrent.
Thank you. All right, Mr. Sinclair, you have the right to address this court before you are sentenced. You can say anything you like. Is there anything you would like to say at this time?
Yes, Your Honor.
Go ahead.
Stand.
Stand, sit, whatever you're comfortable doing.
Thank you for this time, Your Honor. Very quickly, I buried my father and my stepfather within about a year of each other. And I can say without a doubt that October 31st, 2024 is the worst day of my life. As has been talked about multiple times, it was a situation that I was not prepared to deal with. I was going to celebrate my 4th anniversary of my wife, and at that point, I saw that she was having an affair. That moment devastated me emotionally, as I think any person in that situation would be overwhelmed by emotion. In that emotional state, I made a mistake, and that is a mistake that I'll have to live with the rest of my life. If I could go back and change things, I would. Sadly, I cannot. And I am truly sorry for everyone involved in that situation. I don't believe that incident is indicative of who I am as a person. I think those that have talked to me, that know me, my history before and after this event, show that that's not who I am. I have lost a lot because of this incident. The family I helped build and, foster, my career that I worked very hard on, my home, my freedom. This incident has taken a lot from me. Even with that, the isolation, all of that, I have still tried to maintain a positive disposition in my interactions with everyone, and I think anyone that's interacted with me would say as such. I don't believe I'm a bad person or a monster. I'm a person who had a situation where they're overwhelmed and made a mistake, and I believe that that's common for people to make mistakes in when they're overwhelmed with emotion. I do hope that the court will take all this into consideration during my sentencing and give me an opportunity to show that I have an opportunity to try and make things better than this incident. I just hope that I'm not defined by one incident, as I hope no one else is defined by one incident. So,
Mr. Downing, on behalf of the state of Ohio.
Thank you, Your Honor. This court's guided by the sentencing factors over 292912B, and so I use that to kind of guide my argument here. Some of these are more simple and straightforward than the others. The harm that was suffered in this case, I would agree with defense counsel that nobody here suffered serious physical harm, at least under the legal definition of it. As to the psychological harm, it is a little bit less clear, as it is in any case where there's psychological harm, but I think that it would be very reasonable to find or expect that there would be serious psychological harm in this incident, not just from the direct victims themselves, Lisa, John, the children that were there, but also the community. And no, the state does not come here with letters from the school and parents saying, this is the effect that this incident had on my kids. But what I can say is what the state does know from reviewing this case and being there on scene is that when this incident occurred and the school was shut down, parents were advised that there was a shooting at a school. And of course, the first thing that we all think about is that there's a gunman in the school. Thank God that wasn't the case here, but there was still a violent incident that occurred on school grounds. There was still a gunshot that was fired on school grounds, and the school still had to be shut down. And there were parents that were arriving that were crying and hysterical, that had gathered by the edges of the road shutdown. The news crews were there because this is a matter of public interest. And in speaking with some of the witnesses in this case, I know one witness advised me that in the months since this incident, she had to actually pull her child out of that school because of the issues that her child was having based on this incident. Because when this incident occurred, it was morning drop-off, and the children were there at the school. They were either in cars, being dropped off, outside walking into school, or were present in the school and could see what was happening from inside the school. And so of course that they're going to be impacted by this. I would imagine that for a lot of these kids and probably a lot of these parents, this is a seminal moment in their time at this school, unfortunately. Economic harm, it's a little easier to look at, but I think that there has been serious economic harm in this case just through the damage that was caused to the cars. The state did receive a estimate for Lisa Torres' vehicle, about $13,000 that it was going to cost insurance to repair it. There was, so I think that is also present in this case. And no question that the defendant's relationship with the victim or victims facilitated this offense. But one of the factors that the court also considers under 20 and 12 is whether the offender is a parent or custodian, the victim was a family or household member, and the offense was committed in the vicinity of one or more children other than the victim. And that's exactly one of the things that happened here. 10-year-old Carson was in Lisa's car at the daycare when this incident started. 2-year-old Charlie was in the car at the daycare. She was also present during this high-speed driving on Madison Avenue. She was in the car during the chase. She was in the car during the gunshot. This court saw in the state's exhibits that I submitted for sentencing the direction of the gunshot fired out of that car, how it was fired through the window towards the general direction of Mr. Sinclair's car where his 2-year-old daughter was, and although it did not enter the car, it skipped off the top. And that wasn't the result of some kind of careful placement of the gunshot, something that was aimed. That was something that was the result of a struggle where this gun goes off. It was not aimed very well. And so just the fact that it was in this general vicinity towards the direction of a car with a 2-year-old in it. And we're talking about a situation where this easily could have injured or killed somebody. And that is not to credit of the defendant in this situation. The other children that were present, although not family members, as I spoke, children at the school, and the exhibits submitted to this court show the impact on the community, the multiple 911 calls that came in from various parents and school officials, the parents who arose crying and the school being shut down. So the impact, I think, to many children in this case is something that we don't normally see in offenses, let alone even domestic violence offenses where there are children at home. I bring this up because defense did raise this issue first. Of course, the defendant cannot be placed into a different legal category because of his status as a police officer, and State v. Mole is clear about that. But what State v. Mole is also looking at is whether that placement of somebody's occupation puts them into a class that criminalizes what is otherwise legal conduct. We're not really talking about that here because the conduct that the defendant committed was illegal whether he was a police officer or not. His status as a police officer has no bearing on whether something that was otherwise legal is now criminal. And I bring that up because at sentencing, one of the factors that a court is allowed to consider under 20 and 12 is any other relevant factors. And I think that this is still a factor that the court can consider because defense did bring it up. Because he's a police officer during his shift, but off shift, he targeted and assaulted other people. He put a school and community at danger. He attacked another police officer. And more than just the normal citizen, he should have known better. Not just as a citizen, but as a police officer. Presumably, in the area that he worked in Cleveland, he saw firsthand the tragedy of gun violence. He saw firsthand countless domestic violence incidents. He saw firsthand the impact that those incidents have on children and neighbors and the community around him. And now he is that person. He is that person causing that harm. again, the exhibits that I submitted to the court show the impact on the community. That more than 50 law enforcement officers and fire department personnel who responded to the scene, the lockdown of Riverview, the concerned parents, the effort to release the kids during this time. And I think what is most striking about this incident is the complete unnecessariness of it. This was a series of criminal conduct that was separated by time and location, distance. This was something that started at a daycare and then moves down the road. Arguably, the whole thing is occurring down the road as the defendant is speeding and driving recklessly with his child in the car. And then the defendant goes to Riverview, goes to a place where children are being actively dropped off, not just during the middle of the school day, but during this time there's an influx of parents and children that are all outside during this time. And it was October, I think it was trick or treat or Halloween this day, and these children are expecting to go there with their costumes or have their trick or treat parties or whatnot they're doing on that day. And instead what he does is he waits. He waits and seeks out Lisa's car specifically. And when he finds it, leaving that parking lot, he cuts across and rams it, blocking off the parking lot and creating this incident. And then he gets out of the car with a gun, which is not something he had to do. Points the gun at the individuals in the car. He finishes punching out the window and then grabs and physically assaults John, who's in the passenger seat, and points the gun at his head and asks, "Do you want me to kill him?" And Lisa is so understandably upset, terrified by this. One of the exhibits I submitted to the court, I think it was in State's Exhibit 1, it might have been the first two there, are inadvertent photos that Lisa took during this incident. While trying to call 911, she's swiping up on her iPhone and swiped open the camera by accident and couldn't dial the numbers 911, actually took two photographs of the defendant inside the car during this incident. That's what's captured in State's exhibits. And so you can see firsthand what that situation was like. And then as she's pleaded with him to stop, he continues, eventually dragging John out of the car and pointing the gun at him again. Eventually, Deputy Ward has to come and tell him to drop the gun, which he does. In most situations, that would end the incident. But then he attacks Deputy Ward and gets in a struggle with Deputy Ward, injuring him. And there has to be a taser that's deployed. So these are all things that, yes, they're part of the same overall crime. That's why they're in one indictment. But when you look at what really occurred here, these are separate incidences that had multiple stopping points, and at every point where the defendant had a choice to stop or continue. And it wasn't until law enforcement forced him to stop that he stopped. I say this is unnecessary because based on statements here, interviews, and the pre-sentence report, it does appear that the defendant was suffering from the stress of multiple things during this incident. The stress of his job. We see this all the time with police officers, seeing things on the job that they shouldn't have to see. And that certainly has an effect on them. The domestic dispute with his wife, certainly that has to be difficult. And the fact that this is on their anniversary, yes, that has to be very difficult. And his mental health issues, difficult. And although these are significant, although they can be difficult, I don't think they are unique. Many people go through these same exact things every day. And part of being a responsible parent, a responsible adult, a responsible member of our community is managing those difficult parts of life and reaching out when you need help, whether it be to a friend or, in this case, probably something that should have been professional with the mental health issues. And the defendant was certainly responsible enough to do those things. Everything that I can see reading through the pre-sentence report is he's educated, he's intelligent, he is a functioning member of society, he holds a well-respected job. And so there's no excuse why this set of common circumstances should lead to why we're here now. other than he chose not to do those things, to not be responsible. He chose to put himself in this position. He chose to engage in this conduct. And one thing that defense counsel stated, and this wasn't word for word, but I think this was the general idea, was that while the conduct in this case was bad, the indictment as initially filed was disproportionate to the conduct, was one of the first things defense counsel said. As if the allegations in the state, or in this case, are the fault of the state. All the state did here, the prosecutor's office, the police department, the fire department, was react to the defendant's conduct. Responding to the scene that day, fighting with him, investigating, filing the charges. These are all results of his conduct. And then, while he was in the jail, he continued to violate the law completely on his own accord. Nobody forced him to do that. Nobody asked him to do that. And so these charges are reactionary. They are a result of his conduct. It's not to be put on the state. And so how can we as a community be assured of the safety of our daycares and schools? Because we cannot do that alone. We try the best we can to protect our kids from everything. We can't also be worried on top of everything we have going on as parents, citizens of the community. We cannot also be worried about whether somebody is going to decide that on this day, they're going to air their domestic violence situation through a series of violence in the school parking lot during morning drop-off. And I say we, because Ms. Smith mentioned that she's a resident of Cleveland and having the defendant no longer be a police officer, there is a loss to the community. Well, as a resident of Lake County, I'm comfortable in saying that the defendant's presence and actions that day have had a significant negative impact on this community. And so will this happen again? I don't know. I mean, what precipitated this was a domestic dispute combined with some mental health issues. Take your pick. That's probably going on right now with many, many other people in this community. It happens every day, unfortunately. They're common. And in the defendant's specific situation, although he has to go to prison in this case, he's going to continue to be a father. He will continue to have kids. And I think it's well within reason that the mothers of those children are likely to find new partners in the future. And so the things that kind of precipitated this, the mix of romantic partners and children and the stresses of life, that will continue. And so how do we know this isn't going to happen again? We don't. All we can say are that these actions are his choice. And so first, there has to be punishment for that, certainly, yes. But also significant, and I think equally significant, if not more, is that our community has to be protected. This incident on this day was unpredictable. It was uncalled for, to say the least. It was dangerous, and it's a miracle that it somehow did not get worse. But it cannot happen again. So the state is asking for more than the minimum here. I think that is well within reason based upon this situation. The state's going to ask for 12 years. In addition to the prison term, forfeiture on the forfeiture specification, and there is restitution in this case that the state has $1,000 to Lisa Chorba for a deductible and $287.44 for a rental car, and that is based upon the documents that the state received. Thank you.
Thank you. Well, this court has reviewed the pre-sentence report and investigation, the psychological evaluation that was completed. I received the victim impact statement. I have read and taken that into consideration. I have considered the particular facts and circumstances of the offenses that are involved here, the nature of the offenses involved. I have further considered everything that's been said here today. Comments from Ms. Smith on behalf of her client, the statement of the defendant, the statement and comments made by the prosecutor, the recommendations of the parties. All of this is considered by this court in light of the purposes and principles of felony sentencing, which are set forth in 292911 of the revised code. Now, as for the factors in 292912, factors which indicate the conduct is more or less serious, the court finds in regards to the offense that occurred in the school after the defendant rammed his car into the victims, the kidnapping, the abduction, endangering children, the relationships clearly with the victim, his wife, facilitated the commission of the offense. But there were many, many victims here, which makes the offense, quite frankly, in my view, more serious. Been doing this for a long time, but I don't know if I've really ever had truly a community as a victim, and we have that here. The school community is clearly a victim here, and the school community branches out to the family and and parents. The fact that this occurred on the school grounds, in an elementary school grounds, at the time of drop-off, makes this much more serious. The children and the ages of the children make it more serious, and it exacerbates the mental injury suffered by these children. And while there is no measurable tool that I could look at to say, oh, there is serious physical harm, there is clearly serious physical harm. Well, one, I've received a victim impact statement from the victim detailing the impact it had on the child involved here, and I can tell you that there's serious psychological harm in that regard. But in regards to the children that were at the school, the parents that start hearing about this and hearing that there's a school shooting, while this may not be what we typically consider as a school shooting, that's how it's being reported, and that's what's I'm sure going through the minds of every parent and person that hears about this. It clearly causes serious psychological harm. It makes it more serious. The fact that a gun was used makes it more serious, and it was actually discharged makes it more serious. The offense was committed in the presence of a child in the car makes it more serious. Those are all factors indicating the offense is more serious. In regards to the assault charge on a police officer, I find that the defendant's position as a police officer makes that more serious. He's assaulting a fellow police officer. He knows exactly what Officer Ward was doing at that time, what he was supposed to be doing at that time, what he was trying to do, and he engaged him in the behavior that he did. Being a police officer, knowing what the police officer was trying to do, he's still engaged in that conduct. That makes that assault on a police officer more serious. As far as factors indicating the conduct is less serious, I do note the defendant did act under strong provocation. No question. I don't think anyone disputes that. Especially initially, when he confronted them at the daycare. As for recidivism factors, the court finds as factors indicating recidivism is more likely that the defendant did violate conditions of his bond initially. When he was first arrested, he was not to have any contact with the victim in this case, and he did that. He continued to have contact with her. Now that stopped after, I think, our hearing we had on the bond hearing. I don't believe there was any more violations of that after that, but that did occur initially, despite being ordered to have no contact. He did have contact. As for factors indicating recidivism is less likely, there's no prior criminal history at all. No delinquency adjudications when he was a minor, no convictions as an adult. He led a law-abiding life for a significant number of years, basically his entire life. And it was committed under circumstances unlikely to recur. The defendant pled guilty to firearm specifications, which requires that prison be imposed. Prison is consistent with the purposes and principles of sentencing, and the defendant is not amenable to available community control sanctions. Now, as I indicated, I do understand the emotions involved in learning what you learned that morning. But that does not justify, does not excuse the actions you engaged in. And as a police officer, you should know that, and you should know better. And I believe it's appropriate to consider that status as a police officer in this regard. Now, if this conduct had it stopped when you initially discovered what was going on at the daycare center, and the conduct you engaged in there, and approaching the car, breaking the window, making the threats there. If that's what this entailed, I don't even know if we'd be here. But it continued. It escalated. You got back in your car. Time has lapsed, and you continued following them. And you went to an elementary school. Went to an elementary school at the time where kids are being dropped off at this elementary school. And you waited for her. And after she dropped your child off, 10-year-old child off, you rammed your car into hers and engaged in this conduct. And you made the deliberate choice to continue the conduct and to escalate the conduct from when you initially discovered this. And the fact that it was committed on the grounds of an elementary school, again, at the time that kids are being dropped off, makes the conduct that you engaged in more egregious. You also, again, chose to introduce a firearm into these events, and not just introduce it, and you discharged it. Striking the car that your daughter was in, your 3-year-old daughter was in. So lucky that's all that happened. And in regards to the inducing panic, I don't know if you can find conduct which could be more serious or the worst form of the offense than inducing panic than what you have here of engaging the conduct you did and discharging a firearm on the grounds of a school, elementary school, at the time of drop-off, sending the entire community into a frenzy, law enforcement into a frenzy. And while, again, this may not be the typical school shooting that we unfortunately hear about too often in the news media, that's how this is getting reported. And the panic that had to be caused as a result of your conduct is the worst form of the offense I could think of. Considering all the foregoing, the court hereby imposes the following sentence. On count 2, the charge of kidnapping, it's the sentence of the court that the defendant serve an indefinite prison term of a minimum of 4 years and a maximum of 6 years. That sentence shall be preceded by 3-year mandatory prison sentence for the firearm specification. Again, that shall be served prior to and consistent to the indefinite term of 4 to 6 years. On count 5 is the sentence of the court. Defendant serve a term of in prison of 36 months. On the specification for the safety zone specifications, the sentence of the court. Defendant serve a mandatory prison term of 2 years. I'm going to run that specification concurrent with the 3-year firearm specification. And count 5 will be served concurrent to count 2. And count 9 is the sentence of this court, the assault on the police officer. The defendant served a maximum sentence of 18 months. Again, being a police officer and assaulting a police officer under the circumstances that occurred here, make this the most serious form of the offense that could occur. Putting him in that position as well. You should know better than that. Count 10 is the sentence of the court. Defendant serve a term in prison of 18 months. Again, I find this to be the worst form of the offense of inducing panic that you can commit. Court orders that the prison terms imposed in counts 9 and 10 be served consecutive to each other and consecutive to the prison term imposed in count 2. For an overall prison term of a minimum of 7 years, maximum of 9 years, plus 3 years for the firearm specification, which is an overall total of 10 years. Defendant has credit for 210 days